Looks like we are live. Hi, everyone. Good afternoon. Good morning. I am Joe Green, a partner in the environmental group of Kelley, Drye, and Warren out of our DC office. Welcome to today's webinar, where we will be discussing a tool that has been available to companies to get ahead of problems and minimize potential liabilities for 25 years or more, but it's sort of waxed and waned in popularity over that time. I'm talking, of course, about EPA's audit policy. Um, Before we move forward, I just want to say regarding CLE, during the program, there will be a code read towards the end of the program. And in order for you to receive the CLE, please note the code and submit the affirmation form that you received. So I'll be announcing that code towards the end of the program. With me today are Matt Schroeder from Fehr and Wayne D'Angelo, my colleague at Kelley, Drye, and Warren. Matt leads the environmental health and safety practice for Fehr, which is part of the Trilon Group family of companies with nearly 6,000 staff supporting environmental engineering and infrastructure projects across the U.S., based out of Milwaukee. Matt and his team support a wide range of industrial, commercial, and municipal operations in identifying environmental requirements and implementing effective management strategies. Matt is a certified ISO 14001 lead auditor and has completed compliance audits across the country. Wayne, my colleague here at Kelley Drye, is co-chair of our national environmental law practice. He has over 25 years of environmental law experience working at EPA on Capitol Hill, as in-house counsel at a major trade association, and in private practice, where he counsels energy companies, trade associations, and heavily regulated industrial clients on all aspects of environmental law and compliance to help them navigate costly and complicated regulatory obligations and agency scrutiny. Wayne routinely works with clients on regulatory rulemaking, permitting, compliance, and enforcement matters arising under multiple environmental, health, safety, and land use and natural resource statutes. He represents a wide range of industrial and energy clients, including upstream and stationary source oil and gas interests, metal, chemical, and manufacturing companies and trade associations. Wayne also operates under the delusion that he is far taller than Joe and could easily best Matt in a wrestling match. I swear it says this right here on the paper. But before turning the reins over to Wayne and Matt, let me give a high-level overview of what we mean when we refer to EPA's audit policy. If we can move the slide. Thank you. So first adopted formally by EPA in 2000, as you can see here, the policy aims to encourage compliance by rewarding companies that voluntarily look through a formalized audit process at their internal operations, and that they discover and correct potential violations in a prompt period of time. If disclosed appropriately and steps are then taken to mitigate and prevent future recurrence, in exchange, the companies receive a reduction or potentially even full elimination of civil penalties. And so in addition to the original 2000, I guess it really goes back to 1995 when the policy was first implemented. That initial guidance document and going back to the 2000 document, there's a number of subsequent interpretation and FAQ and other guidance documents that sort of flush out the details of the policy and have come to guide it over the last 3 decades. Further, we should note, and in any of these efforts, the states are also must be considered, and many of the states have similar but not always identical audit programs, and companies should consider that as part of any audit process, with the expectation that there will be disclosures which could involve both federal and state officials. Move to the next slide, please. So why today? Why are we talking about it today? Again, as I've noted earlier, it waxes and wanes with popularity depending on the administration. And as you can imagine, the current Trump EPA is pursuing a heavily both a deregulatory agenda. We've heard a lot of emphasis about major rulemakings and pullback on the regulatory front, But also that also entails a distinct change in enforcement posture. We saw this in the first Trump administration, and now we're seeing it again. And that's more of a cooperative effort, both with the states uh, and focusing more of the enforcement and the cooperative federalism between state and federal officials, but also in terms of encouraging compliance, sort of emphasizing that compliance assurance side of the Office of Enforcement and Compliance Assurance at EPA. And so this is a much more amenable time for the things like the audit policy, where companies can have assurance that it could be evaluated by an administration that is more inclined towards compliance and cooperation with the company to achieve and advance that compliance, rather than a more aggressive enforcement posture. And we've seen that already with the Trump administration, going back certainly to the first administration. Again, fewer inspections on site, lower penalties overall, and just a generally more relaxed enforcement environment, at least in some areas. We don't want to overemphasize that it's not like there's a lack of enforcement entirely. In fact, we see it in some areas more aggressively than others. But generally speaking, a more amenable uh, environment for compliance and engagement with companies. Let me turn it over now to Wayne to walk us a little further through in some more detail the essence of the audit policy. Wayne, let me kick it over to you.
Thanks, Joe, and thanks for letting me write my own bio and introduction. That was I was grateful for that. Next slide, please. So, talking about some reasons to do an environmental audit and do so through EPA's audit policy. First and foremost, compliance matters. So it's an opportunity to address past and potential future compliance risks, right? So environmental compliance is incredibly complicated at times, and an environmental audit is an opportunity to have some introspection, look back, and figure out, have you been doing things correctly? Have you been hitting all your marks? A manufacturing company could be regulated under multiple different statutes, tons of different regulations at federal, state, and sometimes local level. They have any number of permits that vary by media, and they're constantly being updated and changing. And those permits can often bring in lots of new requirements by reference or explicitly or otherwise. So environmental compliance is difficult, challenging, constantly moving, and environmental auditing is an opportunity to address those issues in the past and going forward. The reason specifically to use EPA's audit policy, and I may say EPA's audit policy, but this applies generally on the state side as well. Possible penalty reductions. Again, these policies are designed to provide incentives, and so what you can get is potential up to 100% reduction in gravity-based penalties if you meet all the conditions of the audit policy. 75% if the discovery wasn't through a systematic environmental auditing or discovery process, and we'll talk about that in a second. And I guess I should step back and discuss the difference here between gravity-based and economic benefits, right? So EPA has penalty policy. It's actually also a suite of penalty policies. The economic benefit part of the penalty is to make sure that companies who have violations don't gain from their non-compliance. So it's the value that they assess for that was gained by that company for non-compliance or by delayed compliance. The gravity-based component is above and beyond the economic point, and it's the more punitive aspect of the penalty calculation. Is based on the egregiousness of the conduct, the significance of the impacts, or otherwise. So the reductions here, the large part of the reductions are on the gravity-based side, although under the penalty policy, EPA does have some discretion to decide to waive economic-based benefits where they're de minimis, and that's sort of an eye of the beholder type determination. Other reasons, EPA, has a long-standing policy, predates the audit policy, where there's voluntary disclosures. They their default policy, which is, again, they allow themselves significant discretion, but the default policy is not to criminally refer that to Department of Justice. EPA similarly has a policy that where companies do voluntary disclosures, they won't request audit reports and try to dig further in that. They'll take the company's audit results. And going back to the first point, an audit and audits under the EPA's audit policy are a mechanism for continuous process improvement and for your environmental compliance staff, which is not just your environmental manager, but those that work in your maintenance sections and otherwise. The results of an audit and the products that come out of an audit are excellent roadmaps and resources for improved management going forward. Next slide, please. So these are the conditions. There's 9 conditions that need to be met in order to avail yourself of the audit policy, and then it tends to be varied through subsequent policies. As Joe said, audit policy is really a suite of policies. So systematic discovery, broadly speaking, there's a lot of nuance to all these, and I won't get into all of them, but it should be discovered through an environmental audit or a compliance management system, as opposed to a one-off. Now, that is not a full preclusion, like I said, but it does count to the amount of penalty mitigation you get. Voluntary discovery, right? So EPA just wants to make sure that this is truly voluntary. So if it's not through legally required monitoring, sampling, auditing, that you already have to do, right? So this must be above and beyond those types of monitoring activities that you already are required to do by your permit or by regulation. Prompt disclosure, and that is you must provide EPA, you must disclose your violations to EPA within 21 days of discovery. And discovery, again, is a fungible concept here, but it's basically when any officer, director, employee has an objectively reasonable basis for believing that a violation has occurred or may occur. This is sort of a prudent person analysis. It's based on, if a prudent person had the same information, what would they have reasonably believed? What it's saying is absolute certainty is not required. Independence, discovery, and disclosure. So if EPA or state or a third party have identified a compliance issue, then you cannot voluntarily identify it. And again, there's plenty of gray areas here when EPA has, made an inquiry, had an information request, if you've been served by, a notice of intent to be sued by a third party, these things that could impact what EPA would construe as the independence of your discovery. Correction and remediation of whatever violation you had within 60 days. 60 days is the measure for get the full benefit of the penalty mitigation, but EPA recognizes there's lots of different occurrences where that can't happen. Sometimes it's out of the violator or violator's control, like if it's a hazardous waste transportation issue. It could only be corrected during a certain window, like a requirement that occurs must be done within so many days of permit issuance. If it requires a new permit, or if it's a highly technical issue or requires a capital expenditure, EPA will generally work with companies to and provide some penalty mitigation outside of the 60-day remediation window if EPA is convinced that they're moving as expeditiously as possible and are preventing reoccurrence. It takes us to number 6, preventing reoccurrence of the violation. It's pretty much what it says on its face. This is often done by showing that the company has made improvements to its auditing, environmental management system, or training systems, and not a repeat violation. This is one with significant gray area around it. So the specific violation or a closely related violation may not have occurred at the same facility in the past 3 years, or if it's a larger company with multiple facilities, that it's not part of a pattern of multiple facilities owned and operated by the company within the past 5 years. Now, all those subjective terms in there, you can imagine that there's lots of dispute over whether prior violations are repeat violations. No serious or actual harm This is, can have significant adverse environmental impacts, spills to human health of their environment. And the final is, broad, very subjective, but, if you're approaching this audit with with a genuine interest in working with the agency, it is easy to be met. It's just the extent to which the company cooperates with EPA. Next slide, please. So, prior, this policy goes back to 1995, as Joe says, and so everything was done by dealing face to face or on the phone with EPA enforcement personnel, and they've streamlined that to create two categories for disclosures. They did so in 2015. So the fast track here is Category 1. It applies for EPCRA, the Emergency Planning and Community Right to Know Act disclosures, where for basically reporting violations, and those sort of happen automatically. You put the information in a electronic portal that EPA has, and it is resolved, fully complete, full circle, all in one step. And then there's everything else, right? And so many of those are reported through the same portal, but they're only reviewed if and when EPA makes a determination that they're going to have an enforcement action, and then are considering the violation of the penalty. So many of those just hang out in purgatory for a long time until the statute of limitations has run. Next slide, please. There's also tailored incentives that EPA has done for small businesses, which EPA has defined as those with 100 or fewer employees, basically to provide more flexibility, knowing that they don't have sophisticated environmental management shops and dedicated personnel often. So they don't, they're not penalized if the violations aren't discovered through non-systematic means. They can get 100% penalty reduction, even if it, was not through a systematic discovery, if it was through a one-off audit, or if it was done because of government-sponsored on-site compliance activities. And they also can get more time for their corrective actions. Next slide. The new owner audit policy, this is a significant change, right? And this was EPA recognizing that when a company acquires another company or a facility, that's an opportunity for understanding and taking hold of environmental compliance, and that is a good milestone and inflection point for doing environmental auditing and making disclosures. But for tailoring of this policy, it would be really hard to apply those 9 factors. So EPA tailored them, and this has been widely utilized. This is, I think, one of the more significant changes in the policy over the past year. So here I've put on the slide the definition of new owners, just to make sure, I won't read all of it, but all of these go to ensuring that the new owner is truly a new owner and that they didn't have control over or responsibility for whatever the violation was. For penalty mitigation, promptly disclose violations to EPA, or enter into an audit agreement within 9 months of the closing, right? So the audit agreement is important where a company is acquiring a suite of properties, and there's no way you could meet either the 9-month time frame or the discovery time frame. So you enter into an audit agreement with EPA, and within that audit agreement, that opens up the audit, and within there you set forth an agreed upon time frame for conducting the audit. And that gives you some time in order to be able to get your hands around the environmental issues at the facilities you've acquired. The audit agreement has to be signed within 9 months, but the audit itself does not have to be completed within 9 months. And then, as I said, EPA has modified the audit policy conditions in certain ways. So, for instance, systematic discovery, recognize that the due diligence that happens around a transaction is necessarily a one-off event, and so there's no penalization if it's not systematic. Voluntary as long as it occurs before the new owner has its first required monitoring, sampling, or obligation. And for actual and serious harm, there's no preclusion if there is harm that predated ownership and control. And similarly with repeat violations, if the violations that were prior to acquisition and prior to the new owner's ability to control, they don't trigger the repeat violation exclusion. That is a quick run through the audit policy, plenty more detail on all of that, but I'm going to kick it over to Matt, who, as an environmental consultant, runs many of these and can talk more about the actual auditing process itself.
Thanks, Wayne. Thanks, Joe. Can we get the next slide? I know Wayne touched on this, but just kind of wanted to highlight a few sort of additional benefits to environmental audits. I know we're specifically trying to highlight the benefits of the EPA and the state audit policies, but we do a lot of audits for facilities, sort of outside that as well. And I think there are some benefits, whether we're trying to gain the benefits of the audit policy. Just a couple of those. Certainly the ability to try to limit damage to reputation and brand from, an agency finding and bringing enforcement. So if we can find and correct things, certainly when an agency brings enforcement or refers a case for enforcement, there's the opportunity for brand damage or reputation damage, both within the community, within your workforce, within maybe your competitors. And so I think, a regular audit process to find and fix things is something that we really love to recommend. An audit will help, so in addition to finding, clear cases of non-compliance or violations of the law, we're also, an effective auditor and counsel team is going to be looking to identify opportunities for improvement, identify best practices, places where you may be able to improve your process or implement industry standards. So an audit team is not just going to be looking for violations, but also looking to provide those recommendations of ways to really maybe see some improvement in your compliance process. One of the things that I really like to talk about is the ability to maintain control over the corrective action process. So the way I think about that is if the EPA or state agency comes into your facility and they find a violation, they're gonna feel some entitlement or obligation to sort of help you fix that problem, or take that, maybe put that on a much more strict timeline than you would have otherwise chosen to pursue. So I think this idea of self-identification of corrective actions and being able to work through how you would choose to correct those issues is a really strong benefit to an audit process. Just one other one that I'll mention, and if Wayne talked about the new owner policy, which I think is a great thing if you're going through a process of mergers or acquisitions. But also if you have multi-sites and you're trying to figure out ways to sort of implement a consistent compliance process across multi-sites, whether they're new or merged or otherwise, an audit can really help identify those areas where you have inconsistencies, and your audit team can kind of help suggest ways to maybe provide some consistency across your operational footprint. Next slide. Let's talk briefly about planning and environmental audit. I think the most important things here are the sort of the front end of this in defining the scope and the objectives. So are we definitely planning to use the audit policy at the federal or state level? What regulations are we trying to identify? How large of a facility and how complicated is the compliance process? How many days are we going to need to be on site with how many auditors? And that can also incorporate whether that audit team needs to have any specific technical skill set. So if you've got something that's particularly complex, chemical processes or different things where an auditor is going to need to be familiar with that process in order to effectively do the audit. So identifying and assigning an audit team, confirming the audit feasibility, preparing an audit plan really is just, again, kind of going back to that objective and scope and laying that out in a written plan. Typically, the audit team will provide that plan and a preliminary information request. So what kinds of documents would it be helpful for the audit team to review ahead of a site visit? So we'll do a desk review and use that to develop an audit checklist based off of your site-specific permits, maybe your SOPs or procedures, your compliance plans that you may have, so that we really know how to get into those things efficiently while the audit team is on site. And then kind of the final step of the audit is an on-site review of operations, interviews with staff and employees, kind of reviewing records. And then typically there is some follow-up. So certain things that may have been reviewed and the audit team would like to get more detail or more documentation, we'll typically follow up with, sort of maybe a post-visit request for additional information. Next slide. The audit report is important, especially if we are trying to use the EPA audit policy. And I think this is where, discussing this in advance with legal counsel and the consultant team is really helpful to understand what level of detail is going to be required for an audit report. Trying to figure out how, sort of how to present those findings in the case of things that are clear, clear findings of violation is maybe handled differently in certain cases than opportunities for improvement or recommendations for best practices. But at the end of the day, we want to define the code citations that are relevant to the findings. So understanding, is this something that the federal EPA is likely to enforce versus a state agency, and that may be determined based on what state we're working in. But trying to work through these things on the front end of the audit so that everybody knows what's expected at the end of it is really critical. Typically, in cases where we are doing this under attorney-client privilege, the audit team would draft findings to be presented by the consultant to legal counsel for review and preliminary discussion. That allows, sort of the audit team to work through some of those questions, maybe prior to presenting the findings to the client. And that can certainly help with sort of mapping out how we manage the timelines around disclosure and corrective action. But at the end of the day, the findings are going to be presented to the client, and that can be done in a number of different ways, but typically through some sort of written report. Next slide. Wayne really covered this already, so I'm not going to spend a lot of time on it here, but just kind of working through the disclosure process. Again, that management of the timing on this is often critical. 60 days is not a lot of time to implement corrective actions. If we've got multi-sites, if we did an audit at one facility and then we find issues and the client says, well, we think we probably have similar issues at other sites within our operating footprint, certainly kind of thinking through how to manage that, even sometimes how to manage that, or having that discussion before the initial audit can be really helpful. Next slide. I think that was it for me.
Great. Well, thank you. I know we're getting close to the time limit already, but I wanted to see if there were any questions. If there are any questions, I think you could provide them in the chat. In the meantime, I do want to say regarding the CLE, before we forget, I don't want to forget that. So for those who are interested in receiving CLE, you're required to, on the affirmation code or affirmation form that you should receive, in the space next to course code, the code is 3291. And please let us know if you have any questions. That code again is 3291. Otherwise, Wayne or Matt, maybe I'll just toss it over to you. We only have like a minute left on the time, but if you have any thoughts or additional color you thought maybe be, to interject, give a little more flavor about the audit process.
Yeah, the only thing I would add, and Matt alluded to it, is a legal and environmental consultant team is a good way to do this. You get outside eyes, and there are information that you can protect through privilege. It's not airtight, but it allows you to have a bit more introspection, where and self-critical inquiry by if the consultant is hired through a counsel providing legal advice, that is a good opportunity for, as Matt noted, like the timelines by which you have noticed may vary to some degree because the information is going to your attorney first for evaluation of whether there is a compliance issue, and it sort of that team with the legal and technical analysis working together is a great way to sort of help prioritize what needs to be fixed, how quickly, what needs to be disclosed, what can be fixed, but probably shouldn't be disclosed, or doesn't need to be disclosed. So that's why we have done this this webinar the way we have. Because we do think it's important where you have technical expertise working with legal counsel.
Yeah, I'd echo that as well. I think, I mean, we certainly do a number. We do audits, where we don't have legal support, and that's fine. But I think, I do think best practice where we can utilize attorney-client privilege is really helpful to the process.
Absolutely. Well, given the time, I think we need to wrap it up here today. I want to, if you have any questions or would like to reach out to either of us, please do not hesitate. With that, I'd like to thank you all, and please reach out if you have any questions. Thanks again, Wayne, Matt. Have a great one. Thank you all.
Thank you.
Thanks.